point who's going to get what in the case. Now, if lest they try to consolidate all the entities, which Group A, if they're in a great position, they're going to want to fight that and say, hey, I don't want to be with the rest of the group.
Over here in the back. Yes.
Okay, so I'm a rollover from the year before. I believe we signed papers in November, first part of November, so we have not received any notification, nor are we in the big booklet that you looked at on any property. Secondly, I looked online to file a proof of claim. It's around $1,200 fee. Just the court, to file the court fee, or in there, plus there's a court fee.
See, that doesn't
Where did you
sound
see
right.
that?
Where'd you see
Okay.
that?
So if we retain you to do the proof of claim, do we give you the $1,500? That's all part of it. And if we decide not to go any further, then
Yeah, you're,
that's it.
I'm going to be representing every one of you on an individual basis. Now, you're going to say, well, gee, how am I ever going to get a hold of Sandy? I'm not alone in my bankruptcy group. We have something like 15 people in our bankruptcy department. And in fact, we are such a closely knit bankruptcy department. Last weekend in February, we all meet on all-day meetings on the weekend in Florida, so we can go to a baseball game, by the way, but also so we can meet and talk about the cases. And
Do you know how much it costs to do a proof of claim?
I'm embarrassed to tell you that I don't, because my secretary takes care of it. But if you want to email me, I can let you know. And feel free to take a card. I don't care if you retain me or not. If you got a question, go
We
ahead.
will send that answer out to everybody. The lady's question was, she said, we did Woodbridge more than a
Let me
year
make a
ago.
note, and
And
I'll
we
get
rolled
that
over
answer.
our money. Now, all my clients weren't in that situation, so you're with another advisor, but she let the account roll over to another piece of property. She's not listed in the book, and she said the fee looks like it's $1,200 just to file.
It doesn't sound right to me, and I'll tell you why. We just did a case where we filed a massive amount of claims for people, and I would have heard from my law firm if it was $1,500 a piece, because we charged them far less for it. So,
Yeah.
but I'll find out the answer, and I'll email it to you.
Sure, I'll send it out to all of our clients. Paul, did you still have a question in the back?
Yeah.
Paul had a question.
Okay. I transferred money in and it went to trust.
Wait, hold on. I'm making a note. I want to be able to listen. In fact, you know what? When we take we'll take a 2-minute break. I can email my secretary and find out what we're being charged for proof of claim.
Okay, go ahead, Paul.
Okay, so it went into Mainstar Trust because you have to set it up that way for an IRA type base. So it was in that position in Mainstar Trust, and now wouldn't Mainstar Trust be like an escrow company holding the money until this other group said, well, okay, we want to get some money, and they said, okay, what do you got of value, and we'll distribute the money to you. Shouldn't it be protected that way somehow if you're not getting anything of value?
So the question is, he has an IRA that's holding its Mainstar note. And the custodian acts as a fiduciary for record-keeping purposes. You direct the custodian to send your dollars in an appropriate IRS-approved investment strategy. So there would be coordination of paperwork between Woodbridge and Mainstar, the custodian,
Right.
to allow the money to go over to Woodbridge.
Right.
And Paul's question is should they have sent the money if the property wasn't already like secured in terms of being on a first trustee note? And I think it's the timing that they can't put you on the note till they get your money, Paul. It's like your paperwork directs it to go over to Woodbridge.
Isn't it an escrow company? Basically, it's one party that holds both notes, so equal group.
And you're saying the money's still in the escrow company?
No, it is over at Woodbridge, but he's saying, shouldn't there be a responsible party for that not to have occurred that way, is what he's saying.
The money's still with
Probably so.
Mainstar.
Probably so. But again, I'd have to look at the documents. I don't know.
I don't have any documents.
None?
Never sent anything.
No, he's got, we'll give you copies of his stuff. We'll get
There's
copies
gotta be.
over to you. Question
And
in the back
again,
over here?
let me indicate the following.
Yeah.
Most of the documents I've seen have security interest and secured notes. Remember, the problem is, I'll try to make this simple as I can. If I'm going in and I'm buying a house, I have a title company that searches the title record to find out what the liens are. If Rick has a security interest and it's not showing up on title, I get the property, I got to guarantee a title. That lien can't come back at my property later because I didn't have any knowledge or notice of it. That's where the issue may lie in these documents. They all purported to be secured. The question is whether they were properly perfected. Now, outside of bankruptcy, you would say, well, I don't care if you, Woodbridge, if you didn't properly perfect it. I've got a secured note and a secured deed, and you would probably prevail on that. The problem comes in is the Woodbridge entity stands in the shoes now of a bona fide purchaser of property, of real estate. And as a bona fide purchaser, they can invalidate the lien, and that's the problem. However, I don't know if that's the case with every single note. We don't know. Nobody knows. That's why people are saying, you know, we don't know if there's unity among your entire group, because some of you may have valid security interests, some of you may not, some of you may be able to impose an equitable lien, others may not. And that's what you need to look at. And as I'm telling you, I'm encouraging you not to get pessimistic and freaked out about a bankruptcy proceeding. It's not pleasant. Nobody wants to go through it. But doesn't mean you have no rights. So look at that. File a claim, look at your documents, have your documents looked at and determined whether you have an argument. Just because they say, there's plenty of cases where I have the other side saying it's not, and there's not clear under the law how you perfect these type of notes. So that's another argument that may come out later on.
Question over here.
You say look at documents. I don't have any documents. I'm in the same situation he is.
Well,
My IRA is invested, is being held by Main Star Trust. I get a statement from them, how much I have, how much interest has been paid, and it.
Well, then we would call up Main Star Trust and tell them, give us the documents for our client.
Okay.
And if they don't give it to them, I'll go into court and force it.
Okay.
Okay.
So the question
But
again
they will
was,
give it.
the question again was, I'm dealing with a custodian called Main Star, and I have no documents. Well, our clients do have the documents because we gave you copies of them, but Sandy said, if you don't have any paper to prove that your IRA dollars went into the Woodbridge notes, he can force Main Star to give them to
Yeah,
us.
there's got to be paperwork. There's got to be. I mean,
You don't have to force Main Star. You just call them up and they'll shoot it right over.
I can't imagine that there's that
Very
much
easy.
incompetence where they
Let me get some
gave
questions
money.
over
you know.
here. Over here. I'll go. Yeah. Question.
As you said, this bankruptcy thing was just a maneuver for the SEC to get off of Woodbridge's back.
Right.
And they're just buying time to get reorganized or something. What is the likelihood that in a few months, we just, go back to business as usual, that come out of this bankruptcy, and everything is normal again?
Well, there is a possibility it might go back to sort of business as usual. I think it's going to be a deal structure. I think the SEC's complaint is these are unregistered securities. They may have to register them. Now, you're getting in a securities area, which is not my expertise, although I have people in my firm to do that, but
Is it premature to get legal representation? That's what I want.
no, because things are going to move pretty quickly in this bankruptcy case. You don't want to sit around and as I said, people that sit around and wait get eaten up in the system.
Okay, question over here, miss? Let's do this one first. Yeah. Go ahead. Yes.
Me?
Yes.
Okay, so if we are at a point where we don't have further questions about our personal situation and we wanna move ahead, like with having you represent us, what would be our next step?
We've got a sign-up sheet, if you, which you don't, you can do later, but you have a sign-up sheet that if you want us to represent you, it's here. Sign up, give me your contact information, I'll send you a retainer agreement in a couple days, and we'll start looking at your documents and getting your documents.
Okay, so let me just repeat that. You can leave anytime you want. Stay as long as you want. He has to be at a family thing. I have to be at a family thing, and I know he doesn't want to be in this dark conference room forever. But I'm going to put these up front with Vicki from my office, Vicki to Jeff, and you can just print your name and email, and within the next couple of days, mid part of next week, your office will have sent out an engagement letter via email.
Yeah.
Okay. And so just to do the initial retainer, again, the fee, is if you put in $25,000, give you 1%. So you write a check for $250, is that correct?
Yeah.
Sandy? If you put in $100,000, you'd write a check for 1%, that'd be $1,000. If you did $150,000, 1% equals the maximum cap of $1,500. So if you have $200,000, $300,000, $400,000, $1 million, your retainer check cap is $1,500.
Is that a one-time deal? Or-
So that's the retainer. Now,
What does that mean?
yes, let me explain what this means. I'm just as confused as you. So in the meetings that we've had, Sandy, tell me if I'm getting this right. Your estimation is, if we have enough clients, even though they're all going to be in a uniquely different situation, different properties, unsecured, secured, the people that came to the tail end can exercise that privilege of getting the money back early, all that kind of nonsense. We're spreading the fees across everybody, and you're giving us a reduced fee schedule as it is, and probably would cap out at 100,000. So if we had 100 people, we're looking at $1,000. Would that be the right math?
Yeah, that's right.
Did you guys hear that? We have 100 people, and he hit the max of what he's anticipating the total fees would be of 100,000. Then we've all paid $1,000.
And I'm going to stick around for a while today, so if you have
Yeah.
questions, I probably can't answer it on an individual
Yeah.
basis because, candidly, I'm not representing anybody in the case right now, so I haven't poured through 400 documents, but a lot of which I'm seeing, so I know what
Back
they are.
here? Yes. Yeah.
First of all, I just want to say thank you very much for doing this because I didn't know that other thing. Now I understand a little bit more better. So
Thank you.
Yeah,
Thank you very much. You have to bear with me for, oh, sorry, but you have to bear with me, oh, go ahead, just, sorry.
I have one question. I maybe already attached this, but I didn't probably understand.
Doesn't matter, I'll answer
How
it.
does one know that his investment is secured or non-secured? I don't know whether unsecured or unsecured.
So the question is, how do I know for my own sake that I am actually in a secured position? So Sandy's firm is expert in this area. They're going to take each of your file folders and do the due diligent research to identify where you stand in this whole mess. Would that be accurate?
That's accurate, but let me with one caveat here. You are secured. Okay? The question is whether they're going to try to make you unsecured, because there is statements in here saying that that's what the unsecured creditor committee believes, that you're unsecured. But, of course, they haven't done the analysis either, so.
So bottom line, if they hadn't been doing a bankruptcy at this point in time, they would be all secured.
That's correct.
They'd be in a much better position if they got a recorded deed in the right territory geographically.
Right.
Right, okay.
And that's why, in exchange, when I was asked, getting on an unsecured creditors committee, should we just give up our security interest? So no, why would you do that? This is your leverage in the case.
So with this second round that we just did, we have no documents, none. We've received nothing.
Yeah,
Well,
we'll have
we'll
to
round
have
up
them.
your initial documents. We'll round up your initial documents.
If I
Well,
can't
gee,
get
I
it from
might-
him, I'll
might
get it
say it.
from the debtor. If I can't get it from the debtor voluntarily, believe me, I'll get it. Now, obviously, voluntarily is cheaper, it's easier. And usually, as I said in this case, creditors committee counsel, the lead counsel, Richard Pachulski, and I have known each other 35 years. In fact,
Jerry in the back, you have a question, Jerry? I'll repeat it. Okay, Jerry proposed a different kind of a financial arrangement, and Sandy will tell you why that's not going to be possible in this case. But Jerry's question was, okay, if I'm hearing you right, you're suggesting that we get representation from someone who's skilled in bankruptcy, and that person would be an attorney, he or she. And you're suggesting that we would just write a check to get that help. In lieu of, well, Sandy, why don't you represent us on a contingency basis, and when it's all said and done, you get your $100,000.
Primarily because I will tell you, I know of no bankruptcy lawyer that takes work on a contingency basis. Too many variables, when you're going to get your money. I mean, for example, let's assume it's business as usual, they confirm a plan, you're great, you're getting your interest payments, it looks like you're totally secured, I can't get paid. There's no money that came out other than on a monthly basis. I don't wanna work for a year, well, let me put it this way, whether I want to or not, my firm will let me work for a year and then end up getting paid over another year. It's just, if you can find a bankruptcy lawyer to do that, that's great, more power to you. As I said, I know.
I'm not an attorney, but I think it's the type of case that we're dealing here with doesn't afford the law firm to strike it rich because someone did something that was totally egregious and has penalties attached to it, right? The payoff isn't big enough. In order for you guys to hire him for contingency, you've got to do your $400,000, so he's sure he's going to make at least $100. That kind of crazy math.
Well,
right?
it's also a
Yeah.
huge percentage of the recovery that you're gonna end up getting.
Exactly. It doesn't make sense in this scenario, right?
Yeah, I mean,
Yeah, but if there's a law firm that would do it, and we didn't find, we interviewed like 9 different law firms, and no one proposed to us the possibility we could do it this way. But that's a valid question, Gary, I appreciate you asking. In the back over here?
Let me add, there
Yeah.
are, in litigation type cases, there's not only lawyers that'll do it on contingency, there's lawyers running around that, solicit class action stuff all the time. I can tell you, that my experience with them, and not that I'm a charitable organization, but they look for bucks. I mean, I know cases where the lawyers get paid and the clients get like, a free bottle of almond milk. And, to give up 40%, which is what it would require in this, and as I said, I just don't do it, so it's not.
Question.
Yeah, question over here?
Hi.
It's my understanding that there were several different types of investments with Woodbridge, short-term notes, and then also there were investments in certain funds. If one of the clients invested in the funds, would they still be a creditor, or would that just be a speculative investment?
If the fund is in bankruptcy, yes. Now, there are some, there's a couple of things that haven't filed, and I haven't examined those yet. So I don't know the answer if where you are and what you're at, but that's one of the things we're gonna have to look at. Now, let me tell you, if you're not in the debtors and there's a fund out there, how quickly do you think I'll go after?
Yeah, these were real estate investment funds that were offered by Woodbridge.
Mhm.
And I think it's my understanding that those were different than the short-term notes.
They're mentioned in passing, I just haven't analyzed them, and I don't know. There are other entities that are referenced that aren't in bankruptcy, that also have property. I just haven't looked at that at all yet.
Okay, but since these funds are mentioned in the bankruptcy, with regard to filing a proof of claim, would you be filing as an investor, or as a creditor? Certainly with the notes would be a creditor, but with investment in real estate funds, you wouldn't necessarily be a creditor, you might just be speculating.
Yeah, there's another group of committees there's another committee that has people that are in that situation. As I said, I haven't looked at that primarily because I didn't know any of you that were in that position, so
I'm not sure
I didn't focus on that.
asking this question.
So the question was, Woodbridge had several types of notes. They had the first position, they had second positions, and I think they had something equivalent to like an equity position.
Right.
None of my clients were in the second position notes or the equity positions. We only wanted the short-term 5%. So if you're in that case, then you're in that situation, we'll certainly.
Yeah, I'll
Sandy,
certainly look at it,
Can you
but-
take that case on too, that scenario? Maybe you guys can coordinate.
Yeah, you know what,
Yeah.
I don't know enough to tell you, yeah, I can, so why don't we hold off, give me your contact and I'll try to find that out.
But for the bulk of you, everyone else here that's my
What I
client,
don't wanna do is end up with a conflict situation where I'm,
Yeah.
I'm diminishing your interest by fighting these guys' interest.
okay, Dr. Litera?
There's documentation that Woodbridge hired Perkins to take over for Shapiro on October 23rd.
Right.
On November 7th, they started looking for an entity to help fund them during the bankruptcy. So they already declared at that time, yeah, they're gonna file Chapter 11.
My check cleared on the 14th of November, after this all started, which meant that they had no intention of honoring this contract. If I hire you, what is the process of going after them for outright fraud?
Well, the corporation, unfortunately, a corporation can actually still reorganize even if it committed fraud. There may be claims against the principals, there probably will be claims made against the principals in this case, I would assume somewhere down the line. But
If I hire you, is this an added expense?
no, it's part of the same thing, because your situation would be different. It might be that, I mentioned to you earlier, that's where the equitable lien comes in. I have to look at it, see if we can trace the money, and if we can trace the money, the position I would take on your behalf would be an equitable lien.
What? I was assigned the property, and originally when it was brought to my attention, it was listed as 7-bedroom, 9-bath property in LA. When I got it, it turns out it's a 2-bedroom, 3-bath property, even though it was led to believe it was a 7-bedroom, 9-bath property.
I actually don't think that's true, but he's in that situation where he came in the tail and he was secured.
Right, so that's where we would make
His-
that argument.
David,
Now, let me say the following. As
Yeah.
I said, I'm talking about the equitable lien, but then I gotta go back to, there's two pieces to this puzzle, or more than two pieces. I've got one piece of property, and I'm gonna trace which of you were in this one piece of property. And I look at it and say, okay, this property is worth X, we've got Y in claims, we're oversecured. Whether you got a lien or not, I may take the position in the case that we want that asset for my people, because if there's no benefit to the bankruptcy estate, it's fully claimed up, and therefore you should release it to us. So at that point, it doesn't really matter if you're secured or unsecured, but I would also be taking the position that, looking at yours and seeing whether you have a basis for an equitable lien to get at the money that you put in. But I don't know what they did with the money yet.
Quicker. Yeah, Phyllis has a question.
Well, probably kind of the same question as this lady over here. We went in and we put in 25,000 and we got 3 of our interest rates back. For 3 months we got our interest rate. And then they decided that they didn't want to take that property, so do you want to put your money onto the next property? And we said, yeah, we'll wait until they have another property. They didn't come up with another property. I guess that's when they went under all the process. So that makes us unsecured, right?
Did they release your security interest?
Check the drink.
I don't know. We got a call.
Yeah,
They didn't terminate in the documents. So the question is, we knew what property we're gonna get placed in on. We put $25,000 in, and they started paying us the monthly interest, and we collected 3 monthly checks. Then we were told, hey, we're not gonna fund that property. We decided we don't like the numbers on that property. We're gonna do another property, and we'll put you at the top of the list, unless you just want the 25,000 back. No, we're waiting on the next property. And then December 5th happened, and now here we're talking about the bankruptcy.
Okay, the answer to that question is going to depend on where's that money.
Yeah.
Where's that money? Okay.
Paying the
Is it still
salary.
sitting there? It's sitting there.
How can you tell?
And
Now, when you say was that money sitting
Well,
there,
I'm
you
gonna find out.
No,
mean
it's
that money
gone.
sitting in a checking account on the balance sheet of Woodbridge?
On the checking account.
Just giving us
the day
false
of
hope.
filing.
Ah.
Name on it?
So
I
she
think it's
might
gone, they're
qualify
just giving
like
us false
other
hope.
people here. For my money was sitting on the balance sheet, I was in
And our
property.
claim is to get the money back.
It's done.
Now, is that a strong position or weak position?
Be honest.
It's a good position.
It's a good
leverage
position. Okay, it's a levered position, okay. Who hasn't asked a question? You haven't asked a question? Yeah.
Hi, I came in at the tail end, October, so I'm listening to other people in the same situation. My question is, am I gonna get the exact amount of money I invested, or am I gonna take a hit like other people?
I don't know yet until we figure out. It's like trying to do brain surgery without having an MRI. I mean, I don't know which asset you're in, I don't know what the asset value is, and I don't know what the debt is on that particular entity, but that's what I'm looking at.
So the question again was, I went into the tail end of it, Am I gonna get all my money back? And if not, how much am I gonna get back? That's the jump ball, we don't know the answer. Over here?
Yeah, I just want to take you back off the original question there.
What do you say, Neil?
If this is where year 2008, during the Great Recession, I would understand why we're here. Real estate market's going really well in California. He's getting listed on a property that's like, what'd you say, 9 rooms, 3 bathrooms?
7-bedroom, 9-bath property, but then when I signed up, it turned out it was a 2-bedroom, 3-bath.
Doesn't that explain why the SEC is involved? Because there's a
Yes.
lot of fraud in the company? I mean, that's why we're in it. It's not because of the real estate market. There must be a lot of fraud in this company. Are they keeping 2 different books? And are the frauds, are the people who committed the fraud, are they still involved? Is the SEC our friend, or are they working against us? Or
The SEC, well, first of all, the SEC has made allegations, as I said. I haven't seen any proof that there's been fraud yet, and this,
There is.
so,
This
Most
property,
definitely.
I can understand, one of the things listed, 7-bedroom, 9-bath, property value of 14 million plus. So they wanted 6.3 million for this first trustee. Well, you know what, there's not too many properties in LA that are 2-bedroom, 3-bath, worth $14 million plus.
Right.
It's actually worth much less.
That's already, yeah.
okay, so, but hypothetically, if you have fraud, and you might, you can't bring a fraud claim against the debtor. They're in bankruptcy proceeding. You can bring a non-dischargeability action, except for it doesn't apply to a corporation for fraud, because they can still reorganize. There may be claims against the principals,
Reason.
and that'll come out as the bankruptcy case progresses.
But are we going to be able to trust their liability schedule? You said we don't know anything about the case until the liability schedules come out. If they're keeping 2 different books, can't they jockey those numbers around on the liability?
They can, but you've got a lot of, accounting firms that have been appointed in the case. You've got that are very well respected firms. You've got good professionals in this case. You've got Larry Perkins, is the CRO, has been put in to run the day-to-day operations in place in Shapiro. He's not going to commit fraud. Part of the reason they're probably taking as long to get the schedules on file is they probably don't know yet, and they're trying to piece things together. So, but they're not going to file documents that are knowingly wrong.
Hey, let me
So,
continue on that.
yes, you'll be able to rely on them to some extent. What you're not going to be able to, are they going to capture every single creditor? Sometimes creditors get left off. Are they going to capture the values correct or pie in the sky? We won't know that until we look at it, and until we know what they're putting in there. Get a real estate broker to find out what's the real value of this asset. And the other aspect too is, as I've said, what entity are you in? I mean, if you're in an entity where you've got equity value, who cares what the the rest of them look like? It's the one that you're in that's the important one here.
I have a question on that $100,000 cap, so that I can make a decision on what to do here. Are there going to be people that are outside of that are going to incur their own individual costs because they don't fit in that group?
No, because I'm estimating what I think this case is going to run.
Okay.
Okay, I want to go back to Dr. DeLutero's comment. David, have you been out to the property yet?
Well, I'm
Have
sorry.
you been out to the property yet?
No, I haven't.
Okay.
Can I just
Go ahead.
add to it?
Yeah.
Remember, my role in this case is going to be distinct to figuring out where you stand in the priority, what your documents you have, where your money went, and taking a position in the case. There's things that are going to go on in the case that the creditors committee will be able to do that are for your common interest. Some of them are investigating, for example, whether there's fraud, whether those things will be looked at. You don't have to pay separately for that. You've got committees for that. My other role in the case would be to go, hey, Judge, come on, let's keep the
So
fees
our
down here.
retainer fee though is 1% of our investment?
Yes.
Or is it the 1,500? You said
It
Not to
caps at
exceed.
15.
1,500.
And we did that to just try to be fair, because I don't want to sit here and tell you, there's too many people in the room. I can't send a bill every month to you guys, so we're trying to get enough up front, so I don't have to go back to the well too often.
Does that include the filing claim?
Yes, it will. You know, if I take 2 seconds when we're done, I'll try to see if my secretary will answer me on a
You
weekend.
will file electronically proof of claim?
Yeah, we'll file it electronically
In your
for you.
office?
The nuance in filing electronic proof of claim is that for some bizarre reason, if you're not listed as a creditor, we may have to file it by hand, but that doesn't matter for you. We'll take care of it. But I just, $1,200 does not sound right.
Plus,
Who
there
in
was
the
a
world,
court
what if
fee.
I've got $1,000 claim? Why would I pay $1,200?
I don't know, that's what I was wondering, that's when I just said, forget it.
Yeah, no, it's that there must have been something else there.
Okay.
Is there normally a fee though? Is there normally a fee?
I'm not even sure there is a fee for filing a claim
Okay.
in a case.
So we still don't know if there's a fee for filing a claim. It's been told that it would be $1,200 or $1,500. The question was asked was if we hire Sandy, if we hire you and your other 14 compadres there to help us with this, are you going to file the claim for us electronically? The answer is yes. In some circumstances, it may be done on paper, but in either case, you're going to do that for
Right, and we're
everybody.
going to go through, we'll get the documents together for every claim.
You
Now,
haven't asked the
also,
question.
bear in mind, once you file a claim, if it turns out that there's more money owed, or we miscalculated the claim, or you can always amend the claim once it's on file.
Okay,
And
claims can be
Of course,
amended.
we do that for you too. If,
Yeah, question over here?
Explain what a CRO is?
oh, it's, I'm sorry about that, I throw these terms around. It's a chief restructuring officer. It's basically an independent person that's appointed to take control of the debtor, and as I said, it's usually when, you know, because I'm on both sides of this case, I'm like worried I got management that's not smelling very right in the very beginning, even though none of it's true, I'm like worried that there's gonna be a motion for appointed trustee. I get independent management in there so that I can diffuse the trustee motion. It didn't happen in this case. You ended up with a trustee motion anyway because the allegation from the Securities and Exchange Commission was, well, it was appointed, but the guy was appointed by old management, and it's beholden to them. So the consequence of that is the CRO doesn't replace the board of directors. They reconstituted the board in the deal. So put three, presumably, I don't know these guys, they were three independent people.
Question over here?
Hopefully it will be an independent. And you've got a lot of, that's an issue where you've got a lot of constituencies in this case, where your common interest is to make sure that the company's being controlled by the right hands. And that includes the SEC, so.
I have a question.
Question.
Yeah, if we hire you, what's the next step? We see you individually and go through all our papers?
You're always welcome to come see me individually, but what I'm gonna do is you'll sign up, I'll send you a retainer agreement, and then I'm gonna start getting my office to get documents together for your client. But, now,
That's what she does for me.
you got my number, you got my email, even if you don't hire me, you got a question, there's a lot of people, so you have to give me a little bit of, time to get back to you. You may hear from me at 4 o'clock in the morning when I'm checking, going through 100 emails, but
Just don't
I
call.
will respond.
But do you, take care of the claim filing?
Yeah, my office will do it. I also, my partner in Delaware, Greg Housewith, is involved in this as well, because we've talked earlier and how to structure this case. My partner in Pittsburgh, John Steiner, is involved in it, and we've got like 15 bankruptcy.
And is there a fee, involved in that? Another fee
Yeah.
to file the claim?
No, that's part of it.
Sandy, you had a question again?
Yeah. Are different properties being added to the original court document that we were sent, the filing lists properties in California, but my investment was in Snowmass, Colorado, but it's not in this booklet. So are they adding new and more properties?
That document is not the schedules that I'm talking about. The schedules are a lengthy document that sets forth what all the property assets are. There's going to be 138 of those, by the way, okay? Because that's the one document that they can't file one for. They may have addendums to it, but and then it'll list all of the claims and assets. Hopefully, all of them. Sometimes people do get left off. That document is the debtor in possession. They weren't in for financing for operations. That's what that document is.
Those properties are allowed to allow the $100 million to be given over to Woodbridge so that they can continue working operationally.
Now, what it may be, and I don't know, I'm not sure of this, because I haven't really studied that document very closely, to be honest with you. What it may be in that document is a list of the assets that the lender that was in prior to the filing of the case, that is now doing the DIP loan, the debtor in possession loan, that may be their security.
Okay, it just said note holders
Yeah.
and
Yeah.
I didn't.
So, well, it's because if the note holders are secured, they can't dilute you with this new loan theoretically.
Okay, so it's
See,
not
if you
limited to.
Look at this real quick,
property.
official form 309 with this deadline. Okay, someone passed up to me earlier, Sandy's looking at something.
Yeah, there is a
Hold on
March,
second. March 12th?
yeah, I'm
Okay.
surprised.
All right, why don't you announce that then, Sandy?
What's the difference between a claim and a
No,
complaint?
that's not the deadline for filing.
While Sandy's looking at that, someone passed me up a letter here saying that they've been contacted by Contrarian Capital LLC, a multi-billion-dollar money management firm founded in 1995 to purchase your secured promissory note. We suggest and encourage you to consider our offer for 20 cents on the dollar. So that was the point that Sandy made earlier, that if they're willing to give you 20 cents on the dollar, they're expecting to get 3 times that back.
And that's why I said to you, if I'm seeing that
Yeah.
this early in a case.
That's a good sign.
These guys don't put 20 cents to make 10. So they usually want a return on their money, and they don't like to break even. In the cases I've been involved in, it's usually 3 times. So now you're already, if it's 3 times, and you can't hold me to this, because again, I'm like shooting darts. But just from experience, if I'm 3 times at 20 cents on the dollar, I'm at 60 cents on a dollar, which is still not gonna make you happy. I mean, come on, who wants to walk away from 40%, but it's better than 0, certainly, so.
Because they're secure. but we are
Okay,
not.
question, yeah.
What is that date?
Oh, the date is not the date for claims, it's the date for filing complaints to determine non-dischargeability. This goes back to your question. You can file complaints to determine non-dischargeability against the debtor so there's no discharge. The chances are that's gonna get extended, and I'll find out, because it's too premature to file that. Yeah, we would do it for you, yes, but fraud is not a basis for a corporation's non-dischargeability.
It's
There are
only
other grounds.
250 it's only 250
Yes.
apart, so it's okay to me.
You
But then,
showed him.
is there any other fees?
That chair, they cashed the check after they started the
That's not part of the
proceedings,
security then.
knowing that they were not gonna honor this contract that I signed. Is he like one of these reasonable attorneys? Or
He's
yes,
not a
okay,
lawyer.
You know what, this should never have been cashed. This,
Yeah.
or in my case, yeah, you know what, this should have been cashed, we gotta get this guy's check back.
He's not a lawyer. He's, I'm not sure if he's even an accountant, but he's a forensic.
But would he look at something like this specifically?
If you're asking me, is he gonna have a heart and feel bad?
No.
No. If you're asking me if we can put enough leverage on him and say, we got an equitable lien and we're gonna litigate this, and the cost of litigation is, he's gonna weigh that and say, we're better off cutting a deal,
I'll
that
just
may
give
be.
you you see, my figure, it's not normally, okay, it's 50,000. On my particular case, what makes me so angry is I convinced my wife, when the CD came due, hey, let's do business.
Me too.
And when I had to tell her 3 weeks later that now this thing is in bankruptcy, this really kind of put a little bit of a problem between my wife and myself.
I can imagine, my wife wouldn't listen to me at all, so that's.
Well, I mean, I like Rick and I like everyone in the organization, it's just that this really put a real.
I don't mean to make light of it, I don't blame you for being frustrated, and I'm gonna tell you from a personal level, it stinks. The question is what I can do about it, and we've been talking about that in the firm. And I'm not telling you that so far I haven't come up with anything other than the equitable lien. It's not to say I won't, because we're gonna talk about that. If you're saying, is Larry Perkins gonna feel bad, does a lawyer feel bad? Maybe.
But he would show him evidence, look at this, they already have it.
Now, there may be a carve-out, they may take that into consideration, saying,
This is in the court record, he already testified that they are looking for capital during this bankruptcy. They already know they're going to file bankruptcy. Yet, a week after this, they cashed my check.
if Larry Perkins has put in, it doesn't necessarily mean they were,
Did you write it?
he's often put in to do restructuring when you need restructuring. But in this particular case, I would agree with you that I think it's an indication that they already knew they were filing.
I mean, it's, yeah, it's a sum of money, but, you know, it's not billions. It's still something. Does he really want to go through that hassle for $50,000?
Well, David, there'll be a
The
bunch of
problem
people in
is,
your
yeah,
situation.
it's not, you're not alone.
There'll be a bunch of people in that
There's
situation.
other people that put money in 2 weeks or 3 weeks before, and, you know, the theory behind, and, you know, who cares about the theory, but the theory behind bankruptcy is equitable distribution among creditors. Now, if equitable distribution, if you've got enough to pay everybody in full, sometimes there are cases where the creditors all get paid full, but the equity holders get nothing because there's no value beyond it. Sometimes it's, you know, I told you about the mortgage company case where people cashed out at 25 cents on the dollar and we're going to be at 90 by the time the case is done. Bad deal for the people that cashed out earlier. In fact, in the case, the creditors committee wanted me to go and join the trading companies because we knew there was going to be a higher distribution. And I said, I'm not going to do that. If people want to cash out, that's their business instead of waiting for 2 years. So, but the problem is, you know, the problem's unique to you as an individual, but there's 9,000 note holders in this case that are owed money.
9,000.
It's almost 8,900.
Yeah.
So,
Does anyone have a new question?
that's my job,
Anyone who hasn't asked a question, you got,
to look out for you.
Our documents, do we all have to mail you our notes, or?
If you have them, it would be great because it'll keep the cost down. Look, to the extent that you can help me, help you, it's going to be less expensive.
Can you get it from Rick?
Of course, we'll send that stuff for you guys. So we'll CC you, so you know it gets to his office, right? So if you want Sandy's firm to help you, they will get you all their documents, and when we send the email, it'll go to them and you.
Great.
Okay, sounds good. Anyone that's new with a question? Anybody we haven't asked? Did you guys ask? Go ahead, Miss.
Okay, I deal with Ray Kate. He said he's here, but he wasn't here.
He had to leave early.
Okay, but
Yeah.
I wrote a note,
Yes.
to him on May 23rd, 2017. And then I got paid interest right away, May, June, July, August, September, October, November. I then stopped in December. That's considered a short term. He told me it was 1 year, so that's a short term note, correct?
Well, you're here because you didn't get your principal back, correct?
No, I got it until, no, I didn't get my principal, correct, the 140,000.
Yeah, so you're in the right place, yeah. The notes were 1 year notes. And this is just my take on it, I could be totally wrong. When they realized they couldn't beat the SEC, they couldn't convince them that these should not be registered securities. They were in the process of rolling out a 9-month term note. Because whether something's a security or not is very complicated, way above my pay grade. And they were trying to position the notes so they could file a Reg D filing with the SEC and continue with their business model of finding properties that they knew either could be refurbished or fixed up and loan money in a secured position like a first, right, with a spread to make a profit and give you guys a decent interest rate. And that's when you mentioned earlier, it was your feeling that the SEC was putting so much pressure on them that it was a defensive move versus not having money, cash flow, or capital. And so, yeah, you're in the
Again,
same
I'm guessing
position
it's
everybody
not
is.
in any of the papers, it's just my gut feeling.
It's a gut feeling that we're all
So
getting.
how do I know? I don't have any information on that at all.
Anything you filled out with Ray and his staff
Yeah.
is that all the documentation you need.
Okay, so
That's
Ray
all
will
you
pass
need.
it over to you guys, if I'm interested.
Exactly.
Let me also tell you, whether short-term note or long-term note, right now, you've all got long-term notes because you're stuck in a bankruptcy proceeding.
Yeah.
And that bankruptcy proceeding could, some properties may be liquidated and those creditors might get paid off earlier. Some creditors might get stretched out and you can restructure even secured notes. I've taken all due notes, fully secured notes to a bank and stretched them out over 15 years interest only. So, in bankruptcy proceeding, to make it work for cash flow so that they can get paid and creditors can do well. So a lot of it's going to depend on what that plan's going to be. You're too early for that. It will come, and that's what I said. Once the plan goes out there, they have to put forth a disclosure statement which is going to explain all the financial aspects of this case that needs to be looked at, and then you get to vote on the plan. So that we're a while off from that. But I assure you, they're probably working on that structure right now on a business plan of how they're gonna get out of this case. That's the key.
One of the questions over here was, Sandy, if we don't retain you soon, like if we don't sign up on the sheet to say, hey, send me the engagement letter, the contact information, email that to me in the next couple of days, could I call you up in 2 or 3 weeks and retain you?
Well, I'd like to try to get it done sometime mid-February, because I want to know, you know, what my pool is in terms of how many people I'm representing. The other problem is, if I gotta make that March 15th date, if we're gonna file a complaint to determine non-dischargeability, I need to know before I can know the day before. So, you know, the answer, the short answer is, you know.
Yes, and you might have to
I
charge
have to look
slightly
at
more.
it at a time. I don't want to, you know, I don't want to take a case where you've lost a bunch of rights and now I'm.
Time is of the essence. When we sat down a couple days ago, I think we said February 16th. It's Friday.
And every time I have talked to you guys, I have to go back, or even them.
Yeah,
I had to go back and re-look at the docket, because from the last time I looked at the docket when I met with him to the time I'm meeting with you, there were probably 150 documents that have been filed. There are so many people in this case representing all kinds of different constituencies. You know, you've got the government being represented in the case. There's the U.S. Trustee's Office, which is an arm of the Department of Justice, which sort of oversees cases and takes positions. There's a lot of constituencies. Now, they're not all getting paid from the bankruptcy estate. But the jockeying for the ad hoc committee was all about whether those lawyers could get paid from the bankruptcy estate, because they didn't have to go, you know, relying on chasing after their individual folks.
Sandy, we've got a question over here.
Yeah.
That was part of the question. How many of us, percentage-wise, do you need that it keeps our retainer to what you quoted? Would it go, if you don't get enough of us, you just said, okay, if you put 25,000 in, you gotta pay 200.
I'm going to represent you anyway.
Okay, well, that's okay. We're going.
You know what,
with
I'm
you.
not going to leave you high and dry because I didn't get enough money.
No, we're going. I just wondered.
Yeah, I can do more with more. You know, I may, like, you know, well, I won't go to this hearing, it's, you know, to hear it because it's unnecessary, I don't need to do it.
So after the retainers, is month, hourly after that?
It's hourly, but what I'm gonna do, I'm not gonna bill you every month if I go over the retainer. After that, I'll wait, we'll do it on a 90-day basis or something. But I don't, if I get enough people, I'm not going over the retainer for a while.
How much is
And I'm gonna try to keep it down. Also, let me say the following, and you don't know me from a hole in the wall, but I always say this to clients. And I am a bankruptcy lawyer that literally I have repeat business, not because I do a bad job, but a lot of times clients hire me to bulletproof them against the next bankruptcy proceeding after I take care of them. It's not how much you bill, it's how you bill. Okay? I'm not billing you today. I have met with them a few times, they've called me, I haven't billed for that either. I actually really enjoy what I'm doing. I can assure you I'm not going to retire in this case, but what I will get from this case, to be honest with you, while I'm sitting here, I've got 100 potential new referral sources when I'm done if I do a good job for you. So,
For the really big cases.
Yeah.
We have a question over here. Jerry? Yeah, that's good. Thanks. Jerry, you have a question?
Oh, yeah. Well, now you said earlier that you see little evidence of a Ponzi scheme.
Yeah.
doesn't mean it's not. I just said I've seen little evidence of it. Why? Because what's a Ponzi scheme? I don't really have a core business. I took this investor's money, paid you back. Okay, and you've got 138 pieces of real property. Now, whether they were paying at some point, a lot of times companies play a little bit fast and loose. And at the end, they're running out of cash, so they're using investor money. It could have turned into one, but I didn't. The Namco case is an example.
I haven't asked my question.
Oh, sorry.
Oh, okay.
You said you see little evidence of a Ponzi scheme, but now I think a lot of people have seen this, and Rick has a copy of it, from the Reuters news agency in December, saying that the SEC sues bankrupt Woodbridge Group over $1.2 billion Ponzi schemes. So are you saying you know more than the SEC?
No, I'm saying the SEC is alleging it because they're looking at securities violations in their mind, and they're suspecting that it's a Ponzi scheme. But I haven't seen evidence of it, and that's three note holder groups. It's not me. 3 note holder groups. I'm not alone. opposed on the basis that they said, I haven't seen any evidence of it, so why should we appoint a trustee?
Well, if it is a Ponzi scheme like I think it is, what are the odds of recovering any money at all within the next 10 years?
Well, let me go back to again. I was trying to answer this. There's assets, there's real estate to liquidate. So it's not a pure Ponzi scheme, you have assets there. You know, whether there's sufficient assets to cover them all, but by the same token, but there's still assets. If you're unsecured, there's still assets to liquidate. And by the same token, if there may be actions against people that have been taken out and that are net winners when they got 100 cents and you got 80, which is a lot of what happened in the Madoff case, and they clawed that money back to redistribute it. That's the importance of a Ponzi scheme in most of these cases. But I will also tell you, one of the things, as I said, I looked at, I could show you an identical article in NAMCO and that said, oh, the Ponzi scheme in the Persian Jewish community. I don't know if you know about NAMCO.
No.
It was the Persian Jewish Bernie Madoff, where there was, I think it was $800 million in debt. Only our assets weren't worth anywhere near that. They spent, I think $3 million investigating the Ponzi and accounting fees. No Ponzi was found. So I'm not saying it's not possible here. I'm just telling you whether it is or it isn't. The good news is there's assets. That's why I'm a little bit more confident about this case than I would be where I'm sitting and looking at a case where I'll go, you know, what is it? There's no business, there's no assets. Or I've got a convenience store that all I have is inventory and cash flow. That's not the case here. Now, whether these properties have equity above all the debt and there's enough to pay everybody, I don't know yet.
Sandy, look at this real quick. So one of my clients brought this in about electronic correspondence versus paper.
There's a lot of paperwork they're sending.
I suggest we do that. Jerry, one of the takeaways about the Ponzi scheme thing in my mind's eye is this. All of you have been in the note for less than a year. Woodbridge has been doing these notes for several years. I know 2 financial advisors, both located in different parts of the country, that have substantially more holdings placed at Woodbridge than I did. And when the 1-year notes came up, they took the client's money out and suggested a different alternative investment strategy. So in those cases, one of my friends had well over $5 million at Woodbridge, and he's only sitting on 2 note holders of $100,000. My other friend, I've never asked him directly how much money he had with Woodbridge, but it was probably over $10 million. And he only has $500,000 left. Okay? So if there's a Ponzi scheme, there's the possibility of a clawback, meaning that everybody that already got paid off would have to give a proportional share of their money back. Even though they've gotten all their money and their interest, they'd have to put the money back in the kitty to lift up your dollar amounts. Does that make sense?
What if they don't have it?
Well, I don't know what happens if they don't have it, but they go after it. They don't just not go after it. They go after it.
Here's the concern on some of it. Is when I go back to the lawyer fees. So I've been in cases where lawyers have billed $2 million to sue for what they call fraudulent conveyance to claw back money. Only the fees were more than the amount of money they clawed back. And, you know, and you could imagine I went in and complained about that because that's obviously makes no sense. So, anytime you're suing somebody, one of the goals, presumably, if you're a lawyer, is to look at what's my chance of recovering. If the guy's got no money, you know. By the same token, in this case, and I don't know the case, one of the low-hanging fruit in case, and so you always want to be careful, is D&O coverage, whether there's errors in admission coverage on the principals, and whether those policies are intact, and the bankruptcy estate may go after those policies to also increase the pool. I don't know if that's the case. It is the case in a lot of cases I've been in, but those are some of the things that we'll look at. I don't need to look at it because you're going to have, the debtor presumably supposed to look at it, and the committee will be watching over them to look at it. So those are things where the committee can represent your interest on that money. But, I mean, you're right, it's a legitimate question. What's the point in getting a judgment if you can't collect it?
Sandy, comment on this letter real quick, this notification.
The question is what it is?
Well,
Oh,
should we do, should you have electronic?
Well, if I'm hired, I am on electronic, so everything I do is on electronic.
No, I mean for Woodbridge, 'cause they're
It's
giving us-
basically, rather than having to file pleadings in the case by paper, you can file them electronically.
No, I know what that means, I'm just saying, do you recommend that we do that, because they're sending us a lot of paperwork?
Oh, yeah, oh, yeah.
Okay, so then that way we can stop the
Yeah,
paperwork
yeah.
and just get it via email.
You know, not only that, then you're beholden to the mail. I mean,
Exactly,
you know, who knows
okay.
if it gets to you or not this way.
Okay, it just came out about a week or so
Yeah, the
ago.
comment is that you can elect to get stuff via email, electronically, versus hard copy from the post office.
Thank you.
All right, who hasn't asked a question? Is there anybody who hasn't asked a question?
But if we choose to have paper, can we do that too?
Of course. If you just want to get it in paper and be delivered directly to your home, you can do that for sure. Okay, and, yeah,
Rick,
yeah.
this might be premature
Yeah.
in this case, right? After all is said and done, for whatever money we can recover and the losses, and we file it against our taxes?
Naturally. So the question was, is if you took a loss on the Woodbridge deal, could you write it off? Yes, you could. Don't quote me on that. By the way, I have a CPA in my office now, Robert Podkos. This is kind of his area of expertise, but without a doubt, you can write it off. I don't know what limitations would be placed on us.
3,000 a year.
Well, actually, I think it depends upon whether there was fraud, if there was fraud, but I don't think there is fraud, but if there was, I think it changes the dynamics of the 3% cap. But you can ask Robert in my office. He'll research that for you and find out.
Regarding this paper the lady has here, are you suggesting that each of us send something in now, or if we're gonna go with you, you're gonna take it?
Well, I'm gonna do it, but if you wanna get duplicate papers, it doesn't hurt. And it's better to get, rather than killing forest trees off, it's probably better that you do it electronically.
Yeah.
But, you know, you're gonna be getting it from me too, because I'm gonna be letting you know what's going on in the case as we go forward, so.
It never hurts to get electronically.
No, not at all.
Yeah, Mario?
You're saying that if we signed today, the cost would be 1% of our investment? Is there a possibility in the future that we run out of money, then we get a monthly statement, which would, that we'd have to pay to continue?
Monthly, no, I might send it quarterly.
Quarterly?
Yes,
But there's that possibility
Yes, there is that possibility.
that we,
I'm gonna
costs us
try,
more.
yes, I'm gonna try not to let it happen, but it's.
Sandy, let me ask you a question. So for everyone that still has stuck around, you know, we still have a lot of questions. What's the probability that the budget would be 100,000? From beginning to end, what's the probability that a budget?
It's a high probability, because I sat down with two of my partners and tried to figure out what it was gonna cost on that level. Again, I'm not.
So I'm a math guy.
I am not going to reorganize the entire case. If I were representing, for example, I can tell you the budget for the ad hoc note holder committee is 2.2 million. But their role is gonna be a lot more, okay? And I don't even wanna tell you what it's gonna cost for debtors counsel and creditors committee counsel in this case, 'cause
So when you say high probability, you mean 75%?
Yeah.
Okay. So I guess the takeaway is, we still don't have enough information to make everyone's mind feel at ease, because you don't have the assets, you don't have liabilities. Everyone's in a uniquely different situation. Some are maybe in a better situation than others, but you'll take on all the clients as a whole. And with the probably 75% probability, you won't go over the 100,000.
Right, and the reason for this is because, as I said, if you've got 25,000 in it, as my individual client, how much can I spend in analyzing your case? And he who has 500,000, I gotta do the same analysis.
That's right.
Yeah.
So this way, I'm spreading it out differently. Now, if there's different unique things to different cases, now for example, for you, I'm gonna call you and say, hey, we got a great argument for X, Y, and Z. You know, they shouldn't have to pay for that, and so that might be a separate billing.
But like David said, there's a number of people, and my clientele, they're
And
very similar to this situation.
that would be pulled together too.
And that would help.
Yeah, so.
Once again, it always helps. That's why I had the big meeting.
I mean, but really, effectively, you're all separate clients, and
Yeah.
that's the difference
So in
between.
my case, if I hired you at 1%, so I would pay no more than $500?
No, he's not saying that.
No,
He's not saying that. Clarify that again.
that's the retainer.
That's the retainer.
I, 1 hour of my time goes over the $500, but.
So when you're looking in terms of.
But I'm gonna end up with, I forgot what we budgeted, if everybody signs up, I got a much higher retainer, and therefore it's easier for me to do this analysis. Plus, a lot of you are gonna fall into like clumps, groups, we're gonna have, these 10 folks may be in one deal, it might be easy to analyze, there's economies of scale. But, no, that's just the retainer, but I'm telling you, I budgeted so that, I don't wanna have to keep coming back to you guys every, because you're gonna get frustrated, and it's also difficult. It's hard for my firm to collect against 100 people.
What's that, David?
So I would have to do something, we could possibly have to pay thousands.
Let him look at the case first.
I can't answer, but let me ask you a question. If it costs you thousands and I get you your money back, are you gonna be really happy with me? If it costs you thousands and I get you zero, you're gonna be pretty aggravated.
Well, because in my case, like I said, they should never have cashed the check.
You know what, and I agree with you that they should never have cashed it.
But now you're saying that, okay, well, Perkins may not.
No, well, I said if you asked if Perkins is going to be sympathetic, the answer is no. If Perkins is going to be sympathetic to the fact that I got a legitimate argument to get the money back and it's going to cost them a lot of money, and there's a whole group of you that are in that similar position, will they cut some kind of a separate deal to treat it differently? The answer is yes. Remember, most of these cases, at least on the reorganization, 99% of them end up resolving on some fashion because it costs too much money to fight. That's why I said we're business lawyers. We're going to look at this and go, okay, wait a minute, it's going to cost me $1 million to fight this. I'm better off just cutting the deal and appeasing these guys.
Because I take it he's in contact with Shapiro, and with you have this case where you look at this is really unethical what happened.
Well, actually,
do you really want to? Okay, everyone's different, but in my case it's 50,000. Do you really want to possibly lose a whole lot more than 50,000? I mean, do they really want to say, you know what, 50,000? We should have cashed this check. Yeah, okay, we messed up on this particular case. This guy. This came off our back, this is get the check back, should never be cashed.
Okay, well, I can tell you that, all I'm telling you is the following. If I walk into Richard Pacholski, who's Creditors Committee Counsel, and tell him, pay my guy back, he's going to tell me why, and I'm going to tell him because it was a really bad thing, he's going to throw me out of his office. If I tell him, on the other hand, I'm going to bring an action for an equitable lien, and I've got 10 folks that are in this position, and we're going to file this, and we're going to litigate it, now he's looking at it differently.
So it's strength in numbers. It's strength in numbers, David. Here's what I think the takeaway could be for you: is do you want representation? Would it make sense? That with a probably 75% probability that he won't exceed his budget. So that means your retainer would cover his fees, right? There's a possibility he could get knee deep into the mud and he has to ask us all to pay a little bit more money. He'll bill it as regularly as quarterly. Okay? In your circumstances, he's going to see how many people fit your situation, and he's going to present it to the bankruptcy court and say, look, I've got these 15 people. Here's their fact pattern. Here's why you need to settle with us. And they will come to an agreement or not. But before he presents that, he's going to let the 15 people know, here's probably my probability of success, and here's how much money it's going to cost us to push forward the gas pedal and try to pursue this. So you'll know what it will be to make that additional lurch in the car with the gasoline going down the highway. You know what I'm saying? But you're on board for at least the initial setup of doing the initial stuff the correct way. And then you're going to be taken care of at least with contact of information from someone who's done lots of these for 35 years.
What I'm trying to say here, and I'm not making myself clear, is that I'm going to look at your situation and try to come up with a legal argument to support what you're saying, so that I have leverage to get down.
And you need more people, though. The more you have, the better it is for you. Yeah. All
so
right.
Are we going to know first how many we are in the pool before we give you the retainer?
Because I'm afraid that if we get rid of the retainer and then there will only be 5 people going to sign up for you, then we'll be ending up paying 20,000 each.
I will let you know what it's gonna cost. The problem with that is, I guess unless we pick a finite date, it's gonna be like a chicken or an egg thing. How am I gonna tell you how many are in before I know how many are in? Is it better, do you think, if we pick a deadline date and say this is the deadline?
Well, we talked about it, at breakfast the other day.
Well, I didn't want to pressure anybody into doing that, but now that I'm thinking about it, maybe that makes more sense, because then I can tell you on, the day after.
March 4th, you have to file.
Yeah.
February 16th.
February 16th, is
That's
that
a Friday.
You want to just say that's
Ballpark
cut off?
figure of how much we're spending to make sense of our recovery.
Can I take a quick survey real quick? I already know, I just counted the names over there. How many people think that they're leaning towards having Sandy help them? Okay. That's about 5, that's about 10.
That's going to be pretty
How many are not?
25. You already have 20 people on the list.
Yeah, so that's going to be a pretty sizable retainer. I don't think, that's going to get me through an analysis and where we want to go in the case. But if you want to, it may be easier just to pick a deadline and we'll cut it off at that date, and then I'll be able to tell you the next day where we're at.
That sounds good. Let's stick with the 16th.
Okay.
February
Is that right
16th.
for everybody?
Yeah.
So we start, we say we give our fee now, the 250 because I have 25,000. Will I know if I have to add more to what I'm giving you, I'm paying you? When will I know that?
I'll tell you that better when I know what the pool is.
It depends how many people.
So here's the question, if I give you the
What I'll do,
if I give you the $250 now, when will I know if I have to pay you more money? So on Monday, after the February 16th deadline, Sandy, you got to report to me and Pam and everybody and tell us how many people have actively sought you out and are on board. They send in the checks and engagement letters. And if it's you work back and do the math, and if you hit the number,
then
we're fine. And if you don't hit the number, then we'll have to proportionally change it, right? Because we have less people, that we're taking across the sea here in the ship. And the fee would be higher. Okay. At that point, would they have an option to get out?
Yeah, why not?
Okay, so you just heard
It's
it,
not
it's
a
being
flat,
recorded.
it's not a fee that I'm earning, if you, like,
Yeah. All right.
you hear the number, you're unhappy, we'll give you the retainer.
Paul, you had a question?
Going into a trust.
Question, this guy Shapiro, he was the head of this thing, he resigned?
Yeah, he was the CEO.
Okay, so then they put in a new person in charge of it?
Yeah, they put in basically a professional manager, that's the CRO.
Okay, now, I heard somewhere on the, looking through the internet, that they were gonna hire this guy Shapiro.
He is hired.
As a consultant at $175,000 a month.
He was. Now, whether he's still, he was, I don't know if he still is, because I told you there was that term sheet where the board was changed. I don't know if one of the conditions, because it's only a term sheet, which is not the whole document, and they haven't filed the whole document yet. I'm presuming it's going to be a whole document. I don't know if that's one of the conditions, but I can let you know that. I didn't call anybody in the case because I'm not representing anybody, so I don't want to start making phone calls.
Right.
Once I'm in the case, I'll call up the creditors committee or the debtors council.
Could we go after him? Could we go after Shapiro?
I'm not. That's not my function because we don't do litigation. Yeah, but you should certainly look at talking to a lawyer about that if you think that.
So it's a possibility. So Sandy, will you let me know if Robert Shapiro is still being considered an outside consultant?
Yeah, I can call up now and say I'm representing some folks in the case.
All right, thanks. Josie?
For those of us that do retain you or hire you, would you then communicate directly with Rick? Rick, have men?
No, absolutely
Our
not.
paperwork.
No.
Do you send
Rick.
it to him or do we send it to you?
I'll facilitate you getting the
documents that are
paperwork. Go ahead, Sandy.
documents that are public documents, in other words, that third parties have seen, you can send and clear it to Rick. Any communications of our case from this point forward, there's no privilege if he hears it. There's an attorney-client privilege, so I'm your lawyer, not his lawyer, and we need to have a line, be patient. Now, what we may want to do, obviously, if I've got 70 people, it's going to take a huge amount of time for me to call 70 different people. We might want to talk about, we'll talk about that later, maybe what I normally do is have like 5 people that I communicate with on a daily basis. That's stuff obviously I'm filing on your behalf, I send everybody. But that or if you got an individual question, but just for the general thing like what happened as a result of a hearing, I might report back that we picked like 5 people, and the 5 people will then filter the emails or telephone calls out to the rest of you just to cut down on the, because obviously, you don't want to be spending half my life answering, 70 phone calls. But,
Because you can't build the way you build. You can't really, it
yeah,
doesn't
well,
work, it
also,
just doesn't work.
We have
a question over here.
It's more for my benefit because I hardly bill for phone calls, believe it
Okay.
or not.
Question over here, Sandy.
What is the timing for your initial filing a claim for all this?
The question was, what's the timing of the initial filing of the claim?
We're gonna start getting, as soon as we get the paperwork together, you have to file the claim with evidentiary support for the paperwork. So we'll get the amount, we'll calculate the amount out for you, because I'll probably calculate the interest rate and everything for the date, up to the date of filing. I'll probably send it to you to take a look at, because you're gonna have to sign it. And then we'll process the claims. I could say, I'll have a paralegal probably working on that. But as soon as I get the paperwork.
Is there a time limit for them that has to be there?
Initially, there is no bar date. A bar date is the deadline by which you have to file claims. Initially, there's no bar date for filing claims, but normally one is going to get set in the case. I looked at the docket. I haven't seen it has gotten set yet, and it doesn't make sense that it would have been set because there's no schedules. So usually people want to look at how you listed them before you file a proof of claim. But I'm going to probably file a claim. There are claims getting filed because I've seen them. So I'm going to probably file a claim on your behalf as soon as I get the documentation together and the paperwork together. It will certainly be before the deadline. But
So we all want to hurry and get documentation.
yeah. So, but you've got a little time on that. So and I'll that's another thing. I'll put a phone call in and try to check that I can let you know.
Question over here.
Yes, I'm concerned about the expenditure, the bills that we will be receiving from the lawyer's office. My principal against expenditure. What's the problem?
So the trade-off is, the question is, I'm worried about throwing good money after bad money. I'm worried about, look, I put $25,000 in Woodbridge, I didn't get any interest checks. And now, how much more money will I have to put in to get help, to get my 25 plus my interest back? That is a question mark in everyone's mind's eye. I think, Sandy, you said with, as best as attorneys like to do this, that you feel like at $100,000 budgeting, that no matter what the complexity of the transaction is, that there's a 75% probability that would be the end-all, be-all total budget. So
I'm sitting here and doing this because I'm trying to think of, and I'm in a large firm, so I got to clear this through my firm. So let me see if I can talk to my other partners, my bankruptcy force, and come up with something that'll be like at least an outside cap for individuals, so you won't. Let me see if I can do something like that for you.
okay, so Sandy says you'll try to get a cap. You'll try to get a cap.
The problem is I don't. I'm like, as I said, it's like I'm going into do a brain surgery and I like don't have an MRI. I don't know what I got in there, and it's hard for me to predict at this point. But I understand the other side of it.
Yeah.
Very clear. So let me see if I can do something like that. It's easier to do that, and just to tell you, because it's not the first time I've represented a large group in a bankruptcy proceeding. I just represented the entire faculty of the university. But it was easier to set a flat fee because they all had the exact same claim. It was all wage claims. So I knew exactly what the claim was. The complexities here is I don't how many of you got security, how many of you don't, who's in this deal. That's why I wanted to try to do that for you, but we were like wrapping our brains. So let me go back and see if this is
Rick, you could
this
find
is a
out
common
how many is secure. You can group them.
If you were to pick an estimate time for people to get back on that issue, would it be by next Friday?
Yeah, I could.
Within a week?
Yeah.
Okay, question in the back?
I'm just concerned about the retainer fees and the and the legal fees, but and you can correct me if I'm wrong, I believe that it is that exact price.
Oh, the fees themselves?
Yes.
Oh, for sure. Oh, sure, the money you would spend to try to get your money back, that's gonna be deductible for sure. You won't be able to have a write-off on your taxes yet till the whole ballgame's over.
If you have a tax question, we have tax lawyers in my
Yeah.
firm. The last person you want to be asking about taxes is me.
Yeah.
Because I'm a consumer in tax just like you guys are. So.
Yeah. Yeah.
I took tax in school, but I remember how to spell it, but that's about it.
Okay. All right, are we mostly done, or are there any last questions that we should help out with real quick? All right, so Sandy, thanks a lot for taking your
Thank
afternoon.
you all.
coming out here.
And I want to throw you one thing. I know this is like really stressful. You know, it's something I do every day, and it's like sometimes it's hard. It's like a doctor seeing, you know, like a leg sawed off. You get immune to it. I'm not unmindful of how difficult this is for you guys. It's a really unfortunate situation, and particularly the mountain. But I hope the results.